So good morning, everyone. It is a great pleasure today to have Professor Victor Ferrer-Escomella as a special guest in our comparative course, in our course of comparative constitutional law. Professor Ferrer-Escomella is a professor of constitutional law at the University Pompeu Fabra in Barcelona. He is also permanent visiting scholar at the University of Texas School of Law in Austin. And he has been previously visiting scholar also at NYU School of Law. And today he will help us to explore the organization of judicial review legislation in Europe, in particular with a reference to centralized systems of judicial review legislation. The topic of the class is constitutional adjudication in Europe towards decentralization. The lecture will mainly focus on the first part, constitutional adjudication in Europe, essentially because we haven't been able so far to explore the organization of constitutional courts of judicial review legislation. So he will firstly refer to the main choice between decentralized system of judicial review legislation and centralized systems. And in the second part of the class, he will address the developments. There is, or at least this is what he claims, there is a trend in the organization of judicial review legislation in Europe towards decentralization, which is associated, which is connected with developments in the law of the European Union and in the law of the European Convention of Human Rights. Just to contextualize this lecture, let me only remind you what we have so far discussed in the topic of judicial review legislation. First of all, we have addressed the origins with a view to the experience of the United States, so Marbury versus Madison, and prior to that, Federalist 78. Afterwards, we have also covered the expansion, the spread of judicial review legislation outside the United States of America. We have seen that judicial review legislation has experienced a global spread in a number of directions. In Europe, there have been 3 waves of expansion, and the history of judicial review legislation in Europe has been more tormented than in the United States. First of all, because only after World War II entrenched and constitutions had been adopted, and this is a prerequisite for judicial review legislation. And secondly, because the judicial culture or the legal culture in Europe is a culture that, at least at the beginning, was rather reluctant against the idea of having judges reviewing the products of democratic deliberation. However, we have seen that both of these elements have changed with the adoption of democratic constitutions in the aftermath of World War II, and this has generated a rather convincing transformation of European legal culture towards the culture of judicial review legislation. This is the point at which we are arrived in the course. Professor Ferrer-Escomella will help us to address the reasons for the choice of centralization in Europe, which are both historical and functional, and also the developments of this choice, the more recent processes in the adjustment and transformation of the operation of Constitutional Court. I will leave the floor to Professor Ferrer-Escomella. He is a very welcome guest here in Trento, and I hope he'll enjoy staying with you.
Thank you very much. sometimes I'll go to the
Yes,
blackboard.
no worries.
Meanwhile, I can use this as well?
Yes.
Do we have to? Okay. Well, thank you very much. It's a real pleasure for me to be here with a good company of Professor Marco Dani and Professor Roberto Toniati there. It's my first time here in Trento, wonderful place, and I hope I will help you understand the centralized model of judicial review. Please interrupt me as many times as you want, because there's some basic ideas I want to share with you, but we can sort of take different paths depending on your interests. So don't hesitate to interrupt me, to ask questions, or to disagree, or to ask me for any kind of clarification, right? So the first big idea to have in mind is that Europe as a whole, right, really is associated with the so-called centralized model of judicial review of legislation. Right? So the idea that there is a court named Constitutional Court or something like that, right? And that court is the only court that has the authority to declare that a statute, that is to say a piece of legislation, is against the Constitution, right? And this is, I will repeat this several times because it's a basic first idea that sometimes people get confused about this. So what the European model of judicial review is about the existence of a monopoly. Only the Constitutional Court can say this particular statute, this particular piece of legislation is against the Constitution, right? So this is the have. I suppose I have to use this, right? If we have the ordinary judiciary,
You have to turn it on.
Oh. Thank you. So if we have the ordinary judiciary, to simplify a lot, we have courts of first instance, then we can have courts of appeal, whatever the name is, and finally we have a Supreme Court, right? That's the ordinary judiciary in countries around the world, right? So the judiciary is structured hierarchically. At the top you have a Supreme Court, and then you have layers of authority. Separate from that ordinary judiciary, you have the Constitutional Court. Right. And what explains the existence of this separate Constitutional Court is the following reason, right? When someone says that a piece of legislation is against the Constitution, when that question arises, right? So Parliament has enacted a statute, and someone says this statute is against the Constitution. Well, that question is supposed to be a very important question, a dramatic question. And for that question, we don't rely on the ordinary judiciary. We rely on this special Constitutional Court, and we say only that Constitutional Court is authorized to say, no, this statute is not in conformity with the Constitution. Right? At the beginning, I will be very straightforward. There are many qualifications to what I'm saying, but for the moment, that's the idea. Right? Now, we have to explore what are the reasons for this institutional arrangement, right? But the interesting point is that most countries in Europe have chosen this institutional arrangement. So, for example, at this moment there are 27 countries in the European Union, right? Of them, 18 have constitutional courts. So there's a clear success of this model. Not all the countries in Europe have this model, but almost all of them. The vast majority of them have opted for this model. Now, very briefly, to understand the mechanics of this, I don't want to get lost into many details, but the mechanics of how the system works is, as most of you already know, but just to summarize, there's two ways to get to the Constitutional Court. There's two ways to put on the table of the Constitutional Court the question whether a statute is or is not constitutional. One way is direct, right? So some subjects, some organs, some institutions have standing to bring a challenge against the statute. Okay, let's call them challenges. Okay, this is a direct action. So, for example, the parliamentary opposition, the ombudsman, the federal government, right, the public prosecutor, depends on the countries, has standing to directly challenge a statute before the Constitutional Court. Okay? Normally we say this kind of action is abstract, right? There is no concrete case, there is no concrete controversy where the statute gets to be applied. It's an action that is detached from any specific case. So let's call it abstract challenges. That's a direct mechanism. There's another mechanism which consists in the following, right? And Italy is one of the countries that has done most to theorize about this, right? When any of these ordinary courts has a case, let's say a case A versus B, this is a controversy. Two parties get into a controversy, and this controversy is brought to the ordinary courts. When any of these courts confronts the issue whether the statute that is applicable to the case is or is not in conformity with the Constitution, that ordinary court stays the proceedings, stops, and asks a question to the Constitutional Court. So there is a division of labor, right? The ordinary court will decide the case A versus B. But there is an incidental issue. The statute that is applicable may not be in conformity with the Constitution. So then we have to ask the Constitutional Court whether or not the statute is constitutional. So there is this monopoly, right? And so we have to raise that question to that Constitutional Court, because that's the only institution empowered to say that the statute is unconstitutional. Now, let's call this constitutional question procedure. Okay, this is, in English, that's normally the words that are used. So we use constitutional challenge to make reference to this direct action in the abstract, and then we call constitutional questions these mechanisms that allows ordinary courts to suspend the proceedings and ask a question to the Constitutional Court. And as you know very well, once the Constitutional Court gives its answer, then the ordinary judge resumes the proceedings and finally decides the case between A and B, right? If the statute is upheld by the court, the statute will be applied. If instead the statute gets declared unconstitutional, the ordinary court will not apply that statute. Okay, that's very simple, but that's the background we need to have. The idea of monopoly is very important, and I want to share with you something that happened to me. So in Spain, I teach constitutional law in Spain, and I insisted so much in class that, the European model is based on this idea of monopoly. Only the Constitutional Court is empowered to say that the statute enacted by Parliament is against the Constitution, so ordinary courts don't have that authority. I think I insisted so much. Then there was an exam, and the first question in the exam was, for the students, imagine the Spanish Parliament enacts the following statute, and then I described the statute. And then the question is, tell me whether the statute is constitutional or not. And the answer was, I cannot answer this question because only the Constitutional Court can answer the question, right? So, and the student thought that was the correct answer, right? That there was like a trick I had played with them, right? So anyway, but you get the point. There is monopoly. Okay, now, what are the reasons for this arrangement? And as you know, I would say the main architect of this model and the person that originally wrote most of the work to justify this model vis-a-vis the American alternative, right, was Hans Kelsen. as you know. And Hans Kelsen, of course, started some ideas that then other professors afterwards, developed in a more sophisticated way. And the big name in Italy and around the world is Mauro Capelletti, right? Professor of civil procedure in Florence, who also wrote a lot on this and basically followed the Kelsenian theory about this particular question. And the main idea is we prefer this model, this centralized model, because we protect legal certainty better. Right? That's the main idea. And let me explain to you a little bit how this works. You have to understand that this model has to be compared to the alternative, the so-called American decentralized model. As you know very well, in the American model, you have already studied Marbury versus Madison, etc. You don't have a specialized constitutional court. You have the ordinary judiciary. All courts have the authority to say, I don't think this statute is constitutional, therefore I don't apply it to the case. Okay. Now, Kelsen was aware of the American model, and Capelletti, of course, was aware of the American model, and they said, well, yes, we know about that, but in Europe, it's better to have the centralized model. And the main reason they gave was legal certainty. Now, why does legal certainty get better protected if you create this special constitutional court? Well, obviously, if the constitutional court has a monopoly, there's only one voice that is relevant, right? In the decentralized model, in the American way, you have all courts having this power, and of course courts will disagree. So this court says the statute is constitutional, but the other court says it's unconstitutional, right? And of course there's the possibility to appeal to a higher court. Sure, but then a court of appeal says the statute is fine, another court of appeal says the statute is not fine. Sure, eventually a case will get to the Supreme Court, and the Supreme Court finally will say whether the statute is constitutional or not. But this takes a while. This takes sometimes decades before the Supreme Court finally settles the issue. Meanwhile, there is what from a very European perspective we might say chaos, right? Disorder. Instead, if you have a constitutional court, and that's the only court empowered to say whether a statute is constitutional or not, of course, there's no risk of any kind of contradiction, right? Because there's only one voice, one court. Moreover, we have said there is the possibility of challenging the statute directly. This means you facilitate the court speaking, right? So it's not only that there is only one court, but this court will be forced to speak soon rather than late, right? So imagine Parliament passes a statute, the parliamentary opposition says this statute is against the Constitution, okay, I bring an action against this statute, and the court gets to decide, right? We don't wait until the statute gets applied to a case. We directly ask the Constitutional Court to rule on the validity of the statute. But even if you don't have challenges, and there are some European countries that don't have abstract challenges, but they do have concrete questions sent by ordinary courts, still, right? The very first court, the first court of first instance that has the opportunity to apply the statute may directly send the question to the highest court, the Constitutional Court. So the Constitutional Court will speak at an early stage rather than at a late stage. So it's one court that tends to speak at a relatively early stage. Also, another important point in this arrangement is that the decision of the court has general effects, right? And this is especially so when the court declares the statute to be invalid, right? So if the court says the statute is unconstitutional, that decision by the court entails the consequence of expelling the statute from the legal system, right? The statute gets expelled from the legal system. It gets eliminated from the legal system, right? Maybe the discussion will say something later, but Kelsen was sometimes tempted to use metaphors, right? And at some point said, well, Parliament makes statutes. Parliament also eliminates statutes. A statute may be repealed by Parliament, right? So this Parliament has this double function, right? It enacts statutes, and also it modifies or repeals statutes. And then we had the Constitutional Court, right? Now the Constitutional Court can also eliminate a statute for constitutional reasons, right? Well, says Kelsen, this is a little bit similar to Parliament repealing a statute, right? No, it's like a negative legislature, right? So when the Constitutional Court eliminates a statute because it finds the statute to be against the Constitution, the court is behaving like a negative legislature, right? But that's a metaphor, okay? And my recommendation to you is never to give too much weight to metaphors, right? Thousands of pages have been written about what could Kelsen think about this. Kelsen thought that the court must be a negative legislature, and this the court is doing is not exactly what a negative legislature could do. Therefore, Kelsen could be very unhappy. Well, that's stupid, okay? That was a metaphor. A metaphor that Kelsen was aware was of limited value. It was one way of expressing things, but there was no deep conceptual point being made when he said the Constitutional Court is a negative legislature. It's a metaphor, right? I'm sure that if Kelsen had known how many thousands of pages have been spent and wasted and how many trees we have cut to discuss whether or not this the court is doing is in keeping with the idea that the court must be a negative legislature, Kelsen could have said, forget about the metaphor, okay? I didn't say it. Really say it. If we have time afterwards, I can give examples of this, okay? But anyway, when the court says the statute is unconstitutional, that decision has erga omnes effects, general effects. The statute gets eliminated from the legal system. Now, in some countries, this idea of legal certainty was advocated and was implemented very strictly. So imagine the following extreme version of the centralized model, the one France had until the reform of their constitution in 2008. So before 2008, right, the French Parliament made a law, and then there was only one window open, right? It was possible for certain organs, basically the parliamentary opposition, to challenge the statute before the Constitutional Court, the Conseil Constitutionnel, right? But before the statute entered into force. So it was a priori review. Okay, so Parliament makes the statute, then there is the possibility of challenging the statute before the Constitutional Court, but the statute has not yet entered into force. So that's why we call it a priori review, because it's review over a future statute, which is not yet a statute that has entered into force, right? Once the statute had entered into force, that was the end of the story. The statute was immune against any kind of constitutional review. Now, this French version that was changed in 2008, but until 2008, that's the way things went on in France. That French version is an extreme conception of the European model, because if you really want to protect legal certainty, well, you do it very well, right? You say, Parliament makes a statute, wait 1 second, let's see what the Constitutional Court says. Okay, the court has spoken, let's suppose the court has said the statute is okay, end of the story. Everybody knows the statute must be applied. If instead the court says the statute is not constitutional, well, Parliament has to modify the statute because it has not passed the constitutional filter. So it's very efficient, right? So quite frankly, if you thought, and there's a big if here, if you thought that legal certainty is the most important value that we have to protect, there's no doubt in my mind that the European model gets many, many points in comparison to the American model. You are worried about legal certainty? Buy the European model. You don't mind about legal certainty? Then maybe you'll be okay with the American model. Right? Now, I say it's a big if, right? Because, as you can imagine, legal certainty is not the only consideration on the table, right? Many other values have to be taken into account, and maybe the best arrangement is not one that is so clearly biased in favor of legal certainty, but also tries to accommodate other values. Right? We'll say something about that later. Now, a small footnote here. Some scholars, Kelsen, Capelletti actually said this. Some scholars have said, look, the American system of judicial review works more or less in the United States because the United States belongs to the common law family. Right? That decentralized model wouldn't work in Europe because Europe, continental Europe, belongs to the civil law tradition. Right? And what's the difference according to these scholars about the two traditions? Well, in the common law tradition, there is the doctrine of precedent. So if the Supreme Court of the United States, for example, says this statute is perfectly constitutional, that holding binds lower courts. If instead it says that the statute is not in conformity with the Constitution, that holding also binds lower courts. So lower courts have to apply the law according to the instructions, if you want, according to the holdings, the judgments, the doctrines, the jurisprudence of the highest courts. Right? In the civil law tradition, in contrast, we don't have such a thing. Right? If you ask people in Spain, people in Italy, do you think the court of first instance is bound by the doctrines of the Supreme Courts? The official answer is something like this. Strictly speaking, they are not bound, because they are only bound by the law, and they are independent when it comes to interpreting the law. So if the Supreme Court says something, but the lower court disagrees, well, the lower court is entitled to go its own way. In practice, they don't do it very often, because their decisions may be overturned by the highest courts, right? But the fact that in practice, lower courts tend to go the same way as the Supreme Court goes, because of the hierarchical mechanisms we have to ensure that the highest courts get their judgments complied with, doesn't mean that technically, legally, officially, lower courts are bound by the doctrines of the Supreme Court. Right? Whereas in the common law countries, imagine, that's the first thing people learn when they go to law school, right? This Supreme Court precedents, and they bound lower courts. It's like, for them, it's like common sense. Of course, how could it be otherwise, right? And this, by the way, is really taken very seriously. That's why it's so important who gets appointed to the Supreme Court of the United States, because those holdings will really rule lower courts, right? So Kelsen, Capelletti, and other people working in this tradition said, in the common law countries, it is possible to have a decentralized system of judicial review of legislation, because eventually cases get to the highest courts, and particularly to the Supreme Court, and once the Supreme Court speaks, that binds lower court, right? Whereas in the civil law tradition, we don't have this instrument, right? So even if a case got to the Supreme Court, some lower courts might say they disagree, so then we have a problem. So we have to solve that, and that's what we do when we create a special constitutional court and we give it a monopoly, right? Notice, I hope I'm not going to be too complicated in what I'm going to say right now, right? I'm going to say something complicated in some seconds. If you understand it well, if not, don't worry, okay? Someone might say, there's something I'm missing here, because if the Supreme Court in the civil law tradition has not the capacity to issue binding doctrines, and that's why we create a special constitutional court, why is that court going to have the authority to bind it? Follow? I've explained this sometimes to Americans, and they say, we have lost you, professor, right? Because you said that in the civil law tradition, the Supreme Court is not like the Supreme Court of the United States, has a certain weakness when it comes to getting its doctrines actually complied with by lower courts. And now you say to us that you in Europe create a special constitutional court, and how is it that suddenly, magically, that constitutional court does have the capacity to bind lower courts? Okay? What's the technical answer to that? Well, the idea of monopoly. Right? So imagine the constitutional court says the statute is valid. And you are the court of first instance. Okay? And now you disagree. Why is it that you still apply the statute? Well, because you cannot disapply it. Because only the Constitutional Court has that authority. So it's the idea of a monopoly that is doing the work. See? Not the idea of binding precedents. Vice versa. Imagine the Constitutional Court declares the statute unconstitutional. Okay? And now you are the course of first instance. Why is it you don't apply the statute, even if you disagree? Answer: because the statute no longer exists. It's been eliminated by the Constitutional Court. So again, it's not any idea of a binding precedent that is doing the work. It's the idea of the Constitutional Court having the power to expel from the legal system a statute. That's what's doing the work of then making this court of first instance not apply the statute, even if that court disagrees with the Constitutional Court's decision. Okay? End of my footnote. Okay? So that's the beautiful way in which even a civil law tradition that has problems with the idea of binding precedents, of binding jurisprudence, can manage to have a constitutional court actually be authoritative through the idea of monopoly and the idea of a decision declaring a statute unconstitutional to be equivalent to expelling the statute from the legal system. Okay? End of my technical and boring footnote. Now, you might say, well, this is fine, this is fine, this is fine. Sorry, I have sometimes explained this to Americans, and so it's useful how they respond, because it helps us. I have learned a lot from questions asked to me from people from completely different cultures. Right? So what I'm going to say is a typical answer or question I got from some American students of mine. Say, okay, professor, now we understand. So you say that having a court that has this monopoly is better for legal certainty. We get it. Okay. But why create a new court? Why create a new court called Constitutional Court? Why don't you centralize judicial review of legislation in the Supreme Court you already have, right? Right? You understand the point, right? If you want legal certainty, and you say having only one court with the monopoly is a great idea, fine, then use the Supreme Court you already have. Why create a separate constitutional court, right? Well, now, that's a good point, because indeed there are countries in the world, this is a nice comparative law footnote, there are countries in the world that have a centralized system of judicial review, but not a constitutional court. They have centralized judicial review in the already existing Supreme Court. Okay? For example, Paraguay. Okay? So in Paraguay, there is a centralized system. But who has this monopoly? The already existing Supreme Court. They have not created a separate constitutional court. Okay? Whereas in Europe, we have taken that step. It's not only that we have created a monopoly, also we have awarded that monopoly to a new creature, the Constitutional Court. So then the question is, why this new creature? And here is where Kelsen didn't say much, okay? And that's where some other scholars have tried to think about possible reasons, right? And some people did it before I did it, and in my little book I tried to enumerate some of the reasons. Okay. So let me share with you some intuitions here. Well, the first idea is, well, maybe the Supreme Court we already have is already very busy. Okay? The Supreme Court is already very busy with so many cases that we cannot put in their hands this function of controlling the validity of legislation, right? I want to insist on something I said at the beginning. Saying whether or not a statute enacted by Parliament is against the Constitution is a very, very important issue. It's a dramatic question. And we don't want that dramatic question to be answered quickly. Now, if the Supreme Court has so many cases to decide that it's overwhelmed with cases, it's risky to ask them, those judges on the Supreme Court, to tell us whether or not the statute is constitutional. It's too dramatic a question to be put in the hands of busy people. So let's create a special constitutional court whose members will have time to think. Now, again, the extreme case of France. They do have lots of time to think because they have so little to do, the members of the Constitutional Court. But that's the point. That's the point. Imagine this extreme case. Let's decide whether the abortion statute is against human dignity. Wow, wait a second. Let's stop and think. Unfortunately, we don't have any cases that we have to decide urgently, right? Okay. So they are like philosophers in a way. They have time to think. So that's one first reason to have a separate constitutional court. To create a space for reflectivity, for reflection, for critical reconsideration. And you need time for that. Now, second reason is, well, if you create a special constitutional court, you can appoint as members of that court people who may be not the best people to be ordinary judges, right? So typically, and this is nice if you get into the websites of the German Constitutional Court, the Italian Constitutional Court, the Portuguese Constitutional Court, the Spanish Constitutional Court, whatever, who is there? Who are the members of these constitutional courts? Well, you'll find some of them who have judicial careers. So they were ordinary judges, and now they get appointed to the Constitutional Court. Okay, fine, nice, very good. But what else? Well, you'll have professors. You'll have professors. So there's the academic view that is expressed there. So people whose function has been to think, to teach, to read, to publish, to get in touch with other professors in other countries and to create some kind of doctrine, some kind of theory, right? This reflexivity, this philosophical approach to life, right? Suddenly some of these people get appointed to the Constitutional Court. And then you have this nice combination. You have the voice of experience, ordinary judges get appointed to the Constitutional Court, and the voice of what? Philosophy, wisdom, criticism, reflexivity, right? Professors. In some cases, you also have the voice of political experience, right? And that's more controversial. But some people who have had some political career get appointed to the constitutional courts. And we might discuss, if you want, what advantages and disadvantages we get from having people that were politicians in the past being members of the Constitutional Court. But, you know, There's something to be said in favor of some voices on the court having some political experience. So that's another important reason for creating this special court. Another reason is democracy. Democracy. Now, I'm going to simplify. Actually, I'm simplifying all the time, okay? Everything I've been saying so far needs to be qualified, and there are exceptions, and it's controversial. But let's get the big picture first, and then we'll see, right? So, democracy. Now, in Spain, like in Italy, like in many other civil law countries, right? Roughly speaking, if you want to be an ordinary judge, what is it you have to do? Well, study. You finish your legal studies, and then you have to pass an exam to become a judge. There's no politics in order for you to enter the judicial system, right? I was professor at the judicial school in Spain for 10 years, okay? My students are now judges. So 25% of all judges in Spain are my former students. That's terrible, really. And I know about them, and they came from not high-status families, not poor families, but not very rich families, who had absolutely no political connections, zero, who studied very hard to pass the exams to be a judge. And then they came to this school, I thought, to get some further education, and then the king came to Barcelona, and the king gave them the title of Spanish judge. Politics, zero. To get higher in the ladder, it's basically a question of how many years you have been a judge, right? There's some politics at the top of the pyramid, but there's no politics to enter the judicial system. And maybe we are wrong about this, but we tend to think this is a good way to recruit the judges. When we see Americans having judges appointed by the people or by the political branches, we are a little bit skeptical of that. However, we Europeans say, wait a second, this is fine for the ordinary judiciary, right? But when it comes to the members of the Constitutional Court, well, there we change our view completely. Because again, it's so dramatic to say that a statute enacted by Parliament is against the Constitution. This is a very dramatic question, right? We want the members of the Constitutional Court that have this incredible power to say no to what Parliament has decided. We want those members to have some democratic legitimacy. So we want them to be appointed not through these bureaucratic, technocratic exams, but through some kind of democratic filter. So typically the members of the Constitutional Court will be appointed by the political branches. So, for example, by Parliament, or by the President of the Republic, or by, say, in the case of Italy, for example, it's by the President of the Republic, by the Parliament, and by the Supreme Courts. In the case of Spain, most of them by the Parliament. In the case of Germany, all of them are appointed by Parliament, right? And also, interestingly, whereas ordinary judges have tenure until they reach retirement age, so for example, until they reach 70 years, and then they retire. It's a long career they can follow. In the case of the members of the Constitutional Court, in most countries in Europe, there are exceptions, okay? There are some important exceptions. But in most countries in Europe, members of the Constitutional Court sit for a limited period. Of, let's say, 9 years, 12 years, 15 years, but not for life, or not until retirement age, right? And we think this is good because this means that the Constitutional Court gets renewed periodically so that there is no big gap between the jurisprudence of the court and the main currents of public opinion in society, something like this. Okay. So these are the reasons that one could give to say, why creating a specialized constitutional court? And as you see, these reasons have nothing to do with legal certainty, right? Is it now that we should stop? Okay, so I'll stop here. I'll say something more about what I was saying, and then we can take the decentralization question. Interrupt me, please, because I let you interrupt, but I speak so much that then you don't dare to, but do it. Thank you. So I'll see you afterwards. Okay, so before I go on, during the break we had a nice talk, and Professor Toniati made an interesting point that I want to share with you, which is this. Historically speaking, the European countries that created a constitutional court did it because in a process of transition from an authoritarian regime to a democratic regime, so think again about Spain. So we had Franco, the dictator, 40 years, and then there was a transition to democracy. Right? And this happened, of course, also in Germany, in Italy, etc., after the Second World War. If you have this process of transition, and the judges, the ordinary judges you have, many of them worked under the dictatorship and were attached and were loyal to the dictatorship. Maybe they were recruited in light of their ideology. You cannot trust them, right, to now check whether the laws enacted by the newly democratic parliament are or not in conformity with the new constitution. Right. So the quick solution is to say, okay, maybe we'll have to maintain the ordinary judges for a while, but we'll create a separate constitutional court, and the political branches of the new era will be the ones that will make the appointments on that constitutional court. Right. So I didn't say that in my talk, and I have to say that from a descriptive point of view, right? You say, what's the story here? Why so many European countries created a constitutional court? Well, answer, in a process of transition, it's a quick and easy solution to the problem, what do we do with the old judiciary that is, to a large extent, attached to the values of the previous regime? Okay. Now, when I gave my talk, I saw your faces, and you're so young, that I thought I didn't have to tell you about this transition. Okay. So imagine me in Spain telling to my students, the reason we have a constitutional court in Spain is that Franco, etc. Well, that was almost half a century ago, right? So if it's a good idea to have a constitutional court now, it cannot be because of what happened half a century ago, right? Ordinary judges in Spain now are perfectly liberal and democratic and are attached to the new values, and they have been recruited according to procedures that have nothing to do with Franco, right? In Germany, in Italy, the ordinary judges are perfectly in conformity with the existing constitutional order, right? So if we don't let them set aside legislation on constitutional grounds, it cannot be now because we don't trust them because of their ideology, right? That could be a good reason half a century ago, but no longer now. And to the extent I want to update the justification for constitutional courts, and in the interest of time, I didn't mention you that point, but indeed it's a very important point to bear in mind, right? This is, by the way, many things in history happen by accident, and then institutions are preserved for different reasons than the reasons for which the accident took place, right? So something happens because of some specific contingent features, and then a new institution is born, and then, right? Then we inherit a constitutional arrangement which maybe is functional for different reasons than the ones that people had in mind when they did what they did in the past, okay? Okay, now let me say something else which when I wrote this book I didn't have in mind, and then because of conversations with students and some professors, I developed the following idea, which is not very very developed, so that's why I want to share it with you, okay, to see what you think. There is a certain tendency to say the following, right? And it sounds good, but I want to be critical of that. And what one hears very often is the following. Well, in the civil law tradition, right, there is a tendency towards specialization. Right? So, different courts are specialized in different areas of the law. Right? And this goes all the way up. Right? So, for example, in Germany, there are 5 different Supreme Courts. Okay? There are 5 different Supreme Courts. Each is specialized in a particular branch of the law. So there is one specialized in taxation, another one in civil and criminal matters, another in labor law, etc. Right? Same thing in Spain. In Spain, we have a Supreme Court that is made up of 5 different chambers. Each chamber is a separate Supreme Court. Each is specialized in a particular branch of the law. Right? And at least in continental Europe, at the very top, at least you'll have a distinction between courts that are specialized in administrative law and the rest, right? So, for example, in Italy, right, you have the Corte di Cassazione, and then you have the Council of State, right? And you say, well, you know, one thing is private and criminal law, separate thing is public law, right? The public law that regulates the structure and functioning of the administration. For that type of problem, we have a separate branch of courts, and at the top we have a specialized court, the Council of State, right? Okay, and in the common law systems, you don't find this, right? So in the common law system, courts tend to have general jurisdiction, right? So yes, at the first instance, maybe there are some specialized courts, but quickly, as you go up the judicial ladder, right, the Court of Appeals has general jurisdiction, and finally the Supreme Court has general jurisdiction, right? Indeed, the Supreme Court of the United States applies American law without any kind of specialization. So one day it's a taxation case, next day is a labor case, next day is a criminal case, next day is whatever, right? Same thing, the Supreme Court of the United Kingdom. It's a court of general jurisdiction. Okay, now many people say, therefore, if in the common law there's a tendency towards courts of general jurisdiction, whereas in the civil law tradition there is a tendency towards specialization of courts, then you explain why in the civil law tradition in Europe we have preferred to create a specialized constitutional court, right? It's simply another example of specialization, right? It's another manifestation of this tendency towards specialization, right? So we have courts that are specialized, let's say, in criminal and civil law, then courts that are specialized in administrative law, and now we have a court called Constitutional Court, specialized in constitutional law. Well, I remember having read this many times, and I said to myself, well, this sounds correct. Now, I want to share with you the idea that this is exactly wrong. Now, let me ask you, what's constitutional law? I mean, if I ask you, what's criminal law? What do you say? If I ask you, what's criminal law? Don't worry, it's not an exam. Tell me something.
It's a branch of law.
Oh, about what?
That deals with criminal matters.
Sure, and what are criminal matters?
Homicide.
Sure, things like that, right? Penalties for people who behave very badly. Okay, and if I said to you, what's tax law?
It's a field of law.
Okay.
It's about
We agree, it's a field of law, that's good. But don't say that, we know that. But about what?
It's about taxation.
Tasha, what's taxation? What's taxation?
Raising money.
Sure. Money that you pay to the government. Okay, good. And what about private law in general? What do you say private law is?
Private law is law between private individuals and not between an individual and the state.
Between two private individuals.
Yes.
Yeah, so things like contracts, torts, wills, things like that, right? Okay. And if I ask you what's administrative law, what do you say? Say it's a field of law. Good. And what's that field of law about, right? What good do you say? Administrative law. Exactly. It's a relationship between the private individual and a public authority, right? But the administration. Now, if I ask you, what's constitutional law? How do you define constitutional law? Right? Because if we say the constitutional court, is specialized in constitutional law, that's what the specialization theory says, well, we have to have a rough definition, right, of what's constitutional law. What's constitutional law? As different from criminal law, as different from taxation law, as different from private law, as different from administrative law. Well, it's a conceptual mistake. It's not different from. There is no such thing as constitutional law as a special branch that is on the same level as criminal law, taxation law, private law, administrative law, right? Because a constitutional law is not an additional field. It's a perspective on all fields. But it's not a new field. It's a way of seeing the different fields of the law. So there is a constitutional approach to private law, a constitutional approach to criminal law, a constitutional approach to taxation, a constitutional approach to administrative law, right? Because that thing we call constitution establishes certain principles that allow us to construct a platform from which we can see the law in a critical way. So yes, we have this tradition of private law. But wait a second, let's have a constitutional perspective on that. Let's reflect on that from a critical point of view. From the platform that you create through the Constitution. Yes, we have a tradition of criminal law. It has its own body of rules and principles, but let's check that body of law in light of constitutional principles. Same thing about administrative law, same thing about labor law, same thing about taxation law. So constitutional law is not exactly a new branch of the law. It's, on the contrary, a platform from which we see all law. So let me exaggerate a little bit more. It's not that we have created a constitutional court as a new step in the process of specialization, but on the contrary, we have created a constitutional court to stop, moderate the tendency towards specialization. Okay? So let's again, let me exaggerate. Right? So our legal system was getting so specialized that we was running the risk of losing the global perspective, of missing the global point, of not seeing the whole law holistically, right? And through a constitution, we are able to reunite, reconnect, link again the different areas of the law under a collection of common rules and principles. So, what's the point of having a constitutional court then? Well, the point of having a constitutional court is the point of having a forum where there is deep thought, deep reflexivity, deep meditation, deep reconsideration of the whole legal system. There are no experts on constitutional law there. And of course, yes, of course, there are some experts on constitutional law because constitutional law does have some kind of residual objects, things like the electoral system, the parliamentary system, all this, okay, fine. But for the rest of the law, there is no one who is an expert in constitutional law. There's someone who raises certain questions from a constitutional perspective that allow us to reconsider the body of law created by scholars in the field of criminal law, in the field of labor law, etc. Right. So, if you imagine, I suppose I'm idealizing things a little bit, but if you imagine a deliberation among the members of the Constitutional Court, someone is a judge, let's say, who has experience in criminal trials. Another one is a judge that has experience in civil law, private law trials. Another one is a professor specialized in taxation law. Another one is a professor specialized in international law. Another one is a professor who is a professor of constitutional law. Okay, but maybe there's one. Another one is a professor of labor law. Then another one is a prosecutor, a former prosecutor. Maybe someone was appointed because of his political experience. Now they deliberate. What's the point of that deliberation? Well, to bring the different areas of the law together, right? And someone might say, look, excuse me, yes, of course, you come from criminal law, and in criminal law things are like that, but this maybe doesn't make lots of sense because, you know, I am a taxation person, and vice versa, right? The one who's an expert in criminal law says, wait a second, it's very important for us coming from criminal law to maintain this important principle, so don't throw it away so easily, right? So there is a dialectic, if you want, a tension between the universal perspective, the external perspective, the perspective of the critics on the one hand, on the other hand, the perspective of those who are specialized in a particular area of the law, who are very attached to the bodies of ideas that have been created, right? So it's a little bit a kind of a Socratic moment. Socrates, as you know, was an ignorant. You know that. Socrates had no university degree. But the point of Socrates, as you know very well, was go to the piazza, right? And then there were those people that said, I am an expert. Okay. And Socrates says, okay, so you're an expert. Okay, so then Socrates started to ask questions. And Socrates didn't know the answer to those questions, but was trying to show to that person that his claim to wisdom was weak. Now, a friend of mine, Professor Matthias Kuhn, says, judicial review is a little bit like institutionalizing Socrates, in the sense that parliament makes a law, or the government makes a decree, and they are experts, of course. And the constitutional court is not an expert, but simply asks questions to make sure there's some rationale for that law, right? Well, that's one view of the Socratic idea, which is fine. This is not the one I'm now trying to convey here. What I'm trying to convey here is a different level of Socrates. And this is the level where different experts try to be Socratic against the others, right? See? So I'm an expert in taxation. So I have no idea about criminal law. You are the expert in criminal law. But we'll ask questions to you. Don't simply say, I'm the expert here on criminal law, therefore this is what the court should do. Well, wait a second. Right? So the experts have to justify themselves before a broader audience. That's what's happening in the Constitutional Court. So I don't know how much we can be convinced by this idea, but at least I would resist the idea that a constitutional court is simply another implementation of the tendency towards specialization. I think, on the contrary, it's a moment of stopping, a moment of putting some brakes on that tendency, a moment of Socratic, critical reconsideration of the whole legal system. It's a systematic moment rather than a specialization moment. Okay. Sure, absolutely.
So I am convinced by the answer you have given. The Constitutional Court has a restraint against specialization. But could we argue the same point in a different way? Mm-hmm. So the court is part of the process of specialization because it is specialized in constitutional legality, which is a different type of legality compared with the type of legality developed by ordinary courts.
But that's, I mean, this we can present things in different ways, but see, what is true is that the kind of legality and the kind of interpretation and the kind of enterprise we get into when we apply the Constitution is different from the kind of enterprise we engage in when we simply, apply the body of law in a particular area, right? Now, but then the question is, what's the difference between the two enterprises, right? And one possible answer to that question could be to say, the difference is that when it comes to the constitutional legality, it's more asking questions, trying to reconnect the different areas of the law into a harmonic way, rather than a very technical set of doctrines that have been developed over time, so something like that, right? So I agree. I mean, there's no, we can say there's a difference between constitutional legality and ordinary legality, but then we have to ask ourselves, what exactly is this difference about, right? Of course, there's a formalistic answer which says constitutional legality has a higher authority, okay? Because the Constitution is here, and ordinary law is down here. Well, yes, it's true. The Constitution is the supreme law of the land. Ordinary law has a lower authority, but that doesn't tell us much about the quality of, yeah.
Could be the difference that ordinary courts are in the business of interpreting legislation or the law and enforcing it, whereas constitutional courts have only a part of the task of interpretation, but they are more in the business of justifying certain policy choices, certain legislative choices.
Yes, indeed. So, for example, one way of specifying this difference is this, right? So, when a constitutional court is asked whether a law that restricts a fundamental right is valid or not, right? So Parliament enacts a law, the law restricts a fundamental right. And then the question is whether that restriction is legitimate, is acceptable under the Constitution. Now, if the court applies something like the principle of proportionality, it's a very open exercise in part policy making, in part moral reasoning, right? So checking to what extent that restriction is going to serve the goal that it is seeking to serve, right? So that's a technocratic moment. Right? Is this restriction really useful to get to the goal, and is it necessary? Can't we think of an alternative way to protect that goal, which is more moderate, less restrictive of the right than the one that the legislature has chosen? That's the technocratic aspect. And then there's a more moral aspect. Suppose you say the restriction is useful and necessary. What about balancing? You have to assess the importance of the goal that is being achieved against the sacrifice on the fundamental right. That's a kind of openly moral consideration. Now, a constitutional court might find itself in a relatively comfortable position doing this, engaging in policy considerations, engaging in moral reasoning when it applies the principle of proportionality, because of its separate institutional environment, right? I'm a constitutional court, but I am not part of the ordinary judiciary. So don't be surprised if the kinds of things I do are a little bit different, sound, look different from the kinds of things we expect from ordinary courts, right? It's not a problem for me. Actually, some of these courts are not called courts. As Professor Toniati was saying during the break, the French Constitutional Court is called French Constitutional Council. It's not called court. And that's not accidental, right? You're emphasizing the fact that this is not an ordinary court. Actually, it's not called a court, right? So, an adjudicative body that is separate from the ordinary judiciary may find itself in a less uncomfortable position than, let's say, the Supreme Court of the United States, right? Because the Supreme Court of the United States has to show that whatever it does is judicial. Whatever it does is judicial. But the kinds of things we are doing It's the kinds of things you expect from courts, right? That's the point of Marbury versus Madison, right? One of the beautiful aspects of Marbury versus Madison is how much the court de-emphasizes the special quality of the Constitution, right? Of course, there's a tension in that decision. Of course, on the one hand, the Constitution is the higher norm, right? So you have to say, look, let's not forget that in the United States, we have a Constitution which has a higher authority than the rest of the law. Okay, but on the other hand, immediately, Justice Marshall says in Marbury versus Madison, says, but it's law. It's law. It's law, and we courts are in the business of applying the law, right? And so it starts giving examples, right? So imagine you have two rules, and one rule contradicts the other. What do we do? Well, traditionally, judges have resorted to criteria to resolve the conflicts, lex posterior, lex specialis, lex superior, right? That's business as usual. That's traditional judicial activity, right? And the examples he gives are, how many witnesses you need to prove treason, right? The very specific and, legal question that is addressed by the Constitution, right? Because, and up to now in the United States, the Supreme Court has always tried to hide, if you want, how special constitutional adjudication is by saying this is like what we do when we apply ordinary law, right? Whereas a constitutional court is less pressed by this anxiety, right? A constitutional court, imagine, there's reasons why a constitutional court will never do this, but imagine a constitutional court said, ladies and gentlemen, good morning. As you know very well, the Constitution explicitly says that I have the power to review the constitutionality of legislation, okay? There's no doubt about this. It's there, no doubt. Article whatever of the Spanish Constitution, right, says a constitutional court is created with the power of controlling the validity of legislation under the Constitution, right? Okay, so there's no doubt about my authority to do this. Now I've been created as separate from the ordinary judiciary, okay? Now it just happens that I create a discourse that is less legalistic and more philosophical, more abstract, more policy-oriented, for example, when I apply the principle of proportionality, right? And some people are watching and are saying, this constitutional court looks a little bit different from ordinary courts, and the answer is yes, of course, and that's why I'm separate. So no problem. However, if the Supreme Court of the United States is part of the ordinary judiciary, there's a certain anxiety when what the Supreme Court does starts to look a little bit different from what we expect ordinary courts to do. So that's a possible, consideration to bear in mind. Okay. So in response to your point, yes, the difference is constitutional legality is one thing, ordinary legality is another, but then we have to be more specific about what exactly is the difference, and I'm unable to give you a full answer to that, but the Socratic idea helps understand what's special about constitutional legality. The policy-oriented, moral reasoning tendency of the principle of proportionality is another way of understanding this difference. And that's interesting because I don't think we can simply say in a formalistic way, well, the difference is that the Constitution is higher than ordinary laws. Okay, fine, we know that. So what, right? We need something more than that. Okay. So let me turn, in the final 15 minutes we have, to the decentralization question. Right. Because things are happening right now that seem to challenge everything I have said, right? So we in Europe have created constitutional courts. We have good reasons probably for that choice. Of course, there are disadvantages, there are imperfections, there are prices we pay, right? I'm not saying the United States system is not good at all, right? But we understand the reasons that Europeans have taken into account in order to create special constitutional courts. So the idea of the monopoly, the stupid answer that these children of mine gave to me, no, I cannot answer your question because this is the monopoly of the constitutional court. Okay. Now, at the same time, there are tendencies towards decentralization. Tendencies that make ordinary courts here more and more powerful when it comes to checking whether or not a law, a statute, is in conformity with the Constitution. So, in other words, this monopoly is being eroded, is being undermined by certain trends. Now, let me tell you about the three trends, and I think the three trends are like increasingly problematic, okay? Increasingly problematic. Now, the first trend is the following one. As you know, before ordinary judges stay the proceedings and send a question to the Constitutional Court, those ordinary judges are expected to make sure there is not an interpretation of the statute that makes it compatible with the Constitution, right? So before the ordinary judge concludes this statute is in tension with the Constitution, let me refer a question to the Constitutional Court. Before the ordinary judge reaches that conclusion, the ordinary judge must try to make sure how different interpretations of the text fit or don't fit with the Constitution. So the judge must interpret the statute in conformity with the Constitution, in harmony with the Constitution, in light of the Constitution. Okay? Now, if I say this to you, you might say, well, but this is not problematic, right? Because what we have heard at the beginning, right, of my talk is that there is a monopoly when it comes to saying that a statute is against the Constitution, right? So that's the field over which the court has a monopoly, right? So the monopoly is over the following thing, right? Declaring a statute to be against the Constitution, right? Pronouncing a statute to be against the Constitution. Saying that a statute is against the Constitution. That is the field over which the Constitutional Court has a monopoly. But that's different from interpreting a statute in light of the Constitution, right? Interpreting a statute in light of the Constitution is separate, is different from saying that the statute is against the Constitution. The problem, of course, is that, and I'll use the blackboard again, is that you have to have some kind of theory to distinguish what readings of a statute count as interpretation and what readings are so far-fetched, so disruptive, so contrived that they don't count as interpretations of the statute, right? So you have a text here. Here's the statute. You have a statutory text, and okay, you can read the text, and let's suppose you say, well, this reading 1, reading 2, let's suppose reading 3. These readings are still interpretation. So if an ordinary judge chooses one of these readings because under that reading the statute is constitutional, fine, that's interpretation, no problem. However, there are certain readings, let's say reading 4, reading 5, that are completely, are completely against, and that's the problem, right? Against what we take to be the principles that make something an interpretation, so that these readings don't count as interpretation. They count as what? Changing the statute. Okay? So, if we have a theory that allows us to differentiate readings of the statute that count as interpretations against readings of the statute that don't count as interpretations, count as changing the statute. If we have that theory, no problem. We say to the ordinary judges, before you raise a question to the Constitutional Court, work your way in this sphere and try to find a reading that makes the statute comply with the Constitution. If you say, no reading allows me to conclude that the statute is constitutional, then you have to raise a question to the Constitutional Court, right? But of course, you judge cannot choose a reading that doesn't count as interpretation, because that's not within your powers. Right? Well, the problem is that, I don't know, maybe you have some new theory about this. I've been unable to find a convincing theory about how to distinguish one sphere from the other. Of course, there are clear cases, but there are many cases that are not clear at all. I mean, and you could say this is interpreting the statute. I think this is changing the statute completely. And I could give you some, maybe I'll give you some examples in some seconds, but to the extent, at least, there is a gray zone, a zone of cases that are very difficult to classify. You can say it's interpretation of a statute, but you can also say it's changing the statute. The larger the number of cases that fall within this gray zone, the more you are empowering ordinary judges, and therefore are eroding the monopoly of the Constitutional Court, right? Because with the excuse that you are simply interpreting the statute, you're actually setting aside this statute and replacing it with a statute that you think conforms with the Constitution, right? And that might be an excellent idea, but the problem is that it erodes the monopoly that we thought the Constitutional Court has. Okay, so that's the first trend. Afterwards, I'll give you an example if you want. The second trend is European Union law. And I have been told that all of you took a European Union course or are taking a European Union course. So you know already about Cimental, this important decision of the Court of Justice of the European Union that says, and it came from Italy, the case, Cimental, says, you know very well what it says, it's ordinary courts that must, on their own authority, set aside any piece of legislation that contradicts European Union law. Okay? There is no monopoly in the hands of the National Constitutional Court, right? So therefore, in Italy, in France, in Germany, any ordinary court can decide a case and hold that the applicable statute is not to be applied because it breaches European Union law. Okay? Now, this tendency harms the monopoly of the Constitutional Court, right? Right? Because this means, imagine you're an ordinary judge, right? If I'm the lawyer and I say to you, this statute contradicts the Italian Constitution. And you say, I think you're right. Okay, so then what you have to do is raise a question to the Constitutional Court. Right? But if I say to you, oh, but wait a second, the statute is also against European Union law. And you say, yeah. Oh, then you directly set aside the statute, right? So the statute has to be sent to the Constitutional Court if the standard is the Italian Constitution, but is to be disapplied by you directly if the standard is the European Union set of laws. Right? So there is a kind of schizophrenia here. We have a dual system where, for purposes of the national constitution, we have a monopoly in the hands of the Constitutional Court. Instead, for purposes of European Union law, we have a decentralized American way of adjudication. Now, is this a problem? Now, as you know, there's always the formalistic person. The formalistic person says there is no problem because in one case it's the Constitution, in the other case it's European Union law. Okay, we understood that, sir. That's exactly the question. How to justify this different treatment? So a deeper answer could be, and sounds plausible for a while, is to say, well, the Constitution is, as we said before, very abstract. It establishes basic principles of justice. It generates this kind of Socratic moment. It's so, of course, we want the Constitutional Court to test whether a statute complies with the Constitution. Instead, European Union law is very technical, very detailed, so that may be put in the hands of ordinary judges without much of a problem, right? Also, if any of these ordinary judges is not very clear what to do, can send a question by way of a preliminary reference to the Court of Justice of the European Union, right? Why do I say this is plausible for a while, but maybe not plausible anymore? Well, now we have, as you know, the Charter of Fundamental Rights of the European Union, right? It's not possible to say European Union law is basically technical, detailed, a kind of regulation that has been elevated to the highest level. No, now the Charter of Fundamental Rights of the European Union is equivalent in quality in the terms it uses to express its provisions as a national constitution, right? So if a national constitution is abstract, open-ended, open to policy making, open to moral reasoning, open to some kind of Socratic enterprise, same is true of the Charter of Fundamental Rights of the European Union, which also is of a very abstract quality, points to basic principles of justice, also generates a proportionality analysis, etc., right? So then we start to be in a more difficult position now to justify this combination, right? Again, let's go back to my example with you. Sorry, your first row, right? I say to you, judge, this Italian statute violates freedom of speech as protected by the Italian Constitution. And you answer, well, I have to send a question to the Constitutional Court for this. And I said to this, but wait a second. It also violates freedom of speech of the Charter of the Fundamental Rights of the European Union. For that point you're making, lawyer, I can directly set aside the Italian statute. Well, we have to think about whether this combination is tenable. And if so, why? And under what conditions? It was easy so far, but it's no longer easy because of the Charter. Third trend, I'll stop here, is, we have the European Convention on Human Rights. It has nothing to do with the European Union. As you know, there is this international treaty called the European Convention on Human Rights that is applied by the Strasbourg Court, okay, the European Court of Human Rights. And there is no cimental there, okay? The Strasbourg Court has never said what national courts must do when they confront a statute that is against the European Convention, okay? Whereas the European Court of Justice of the European Union did decide in the cimental case that ordinary courts must set aside national legislation that contradicts European Union law. No equivalent holding has been made by the European Court of Human Rights. The European Court of Human Rights has said each state is free to organize its sources of law as it thinks better, and to organize its own judiciary as it thinks better, and to decide what to do about to have a centralized system, decentralized system, mixed system, you choose it. No problem. We want outcomes. We don't want human rights to be violated, okay? That's the outcome we want to guarantee. But how internally you organize yourselves, we don't care. Okay, so then the question is, how should we organize ourselves? And there's basically three possibilities. There are more, but for our purposes there are three. One is what we might call the Italian-Austrian answer. The Italian-Austrian answer is to say, look, we are not crazy, we have a constitutional court, we have good reasons to have a constitutional court, therefore, we maintain the monopoly. Therefore, if an ordinary judge thinks a national statute violates the European Convention, we must send the statute to the Constitutional Court. Okay? Get that? Right? So in Italy, for example, if an ordinary judge thinks an Italian statute is in violation of the European Convention on Human Rights, that's for the Constitutional Court. There's a monopoly. Right? Same thing in Austria. In Austria, the European Convention is taken as if it were part of the Austrian Constitution. So if an Austrian statute seems to violate the European Convention, that's for the Austrian court. Well, that's very coherent. I mean, I personally like that answer. It's coherent. If you have a constitutional court and you think you have good reasons to maintain it, okay, maintain it with the basic feature, which is the monopoly when it comes to testing legislation under higher norms. Then there is another answer, which is a French answer, which is to say, oh, no, we allow any ordinary court to decide that a statute contradicts international treaties like the European Convention. No? So there is a contrôle de constitutionnalité, that's for the Constitutional Court, and there is a contrôle de conventionnalité, that's for ordinary judges. Well, there are people in French who are critical of this because they say, this is a little bit schizophrenic, right? So why should we be centralized, Kelsenian, when it comes to control the constitutionality, and suddenly American, right? Marbury versus Madison kind of people, when it comes to control the conventionality. So there are some people saying we should go towards the Austrian-Italian solution. But anyway, that's the French answer. Then there is the Spanish answer. The Spanish answer is we have no idea. We have no idea what the Spanish answer to this is. Okay? So we have space for arguments. I have made the argument in favor of the Italian solution. But the Spanish Constitutional Court has yet to decide. And we don't know. I told my students, please, one day, do this. Decide a case and say in your decision, I don't apply this Spanish statute because it violates the European Convention on Human Rights. Say it frankly. And let's see what happens. But no judge has dared do this, unfortunately. So we don't have any case to see what the court decides, right? But, okay, we have the Italian, Austrian centralization, the French decentralization answer, and the, I don't know, kind of answer from Spain, right? As you can imagine, after devoting so many years to thinking in favor of the European model, I think the Italian-Austrian solution is better, right? But who knows? Who knows? I have, again, comparative law is listening to the other, right? Every time I explain this to my American friends, who are, all of us are provincial, okay? You're attached to things you're familiar with, right? Spanish people are provincial, Europeans are provincial, and Americans are provincial, right? So when an American scholar hears all this story, and at the end you say to them, oh, by the way, there are these decentralizing tendencies, suddenly their eyes start to open. Yeah, because through interpretation, and then Cimental, right? And then the French control the conventionality in a decentralized manner. The American will say, finally the Europeans are seeing the light. They are quick, they are gradually destroying this artificial thing they created, called Constitutional Court, with this all very strange idea about legal certainty and the special quality of the Constitution and this Kelsen they talk about all the time. But finally, the pragmatic reason prevails, right? Let ordinary judges apply the whole law, which is very complicated, very sophisticated, it has different layers of authority. You have an ordinary court, an ordinary statute, you have the Constitution, you have European Union law, you have the European Convention, maybe you have United Nations norms. It's a very complex body. Let them apply the lex superior principle all the way down. And don't create a special artificial exception when it comes to the problem whether a statute is against the Constitution. Come on. I mean, this is simply an example of many other conflicts in the life of the law. So why create all these arrangement with this special constitutional court simply because of all the possible conflicts that arise, there is one that you are particularly obsessed about, a statute and the Constitution. So then we go back to the initial question. What is special about saying that a statute is against the Constitution? If you think there's something special, that's a European intuition, and then you understand why we have done things that we have done. If you say, at the end of the day, I don't see much that is special here, it's simply a conflict between two rules, then your American heart will start to kick in, and you'll start to say Marbury, okay? Okay, so that's it. It's thank you. What time do we end? Already. Okay, thank you a lot. Sorry you didn't interrupt me, but I forgive you, okay? But next time you'll interrupt me. Thank you.
I think I can speak also on your behalf in thanking Professor Victor Ferrer-Escomella for this great guest lecture and for this exploration of the distinction not only of technical arrangements but also of legal culture between the world of decentralized judicial review legislation and centralized judicial review legislation. We'll continue tomorrow on this topic. We'll cover other aspects which are related to what Professor Ferrer-Escomella said today. And again, thank you very much.
No, thank you. It was my pleasure to be here with you. And first time here in Trento, wonderful place and a wonderful collection of students. So thank you for having me here.